We are recording.
Okay, it looks like we are recording and officially in the public webinar. Welcome to our April Law School Council meeting. I'm Professor Devin Kenyon from Santa Clara University School of Law and have the honor of serving as our chair. I will ask that everyone sort of remember their Zoom best practices, which is to keep yourself muted when you're not speaking, to use the raise hand function when you're ready to be called on and comment on. And we'll start by asking the bar staff to take the roll for the council, please.
Certainly. Devin Kenyon.
Present.
Don Smythe.
Present.
Grace Hum.
Present.
Susan Bakshian.
Present.
Jennifer Newcomb. Christopher E. De Don. Nidia Duenas. We have quorum.
Good. And it looks like Media just joined us, so she is present as well. Next, we'll move on to public comment. I will note that as the chair, I reserve the right to limit public comment limit the time for public comment, and I'll ask staff to recognize people who wish to deliver public comment.
Thank you. And at this time I do not see any hands raised. There's no public comment.
Great, thank you. Then we will move forward to the approval of the minutes from the December 3rd meeting. I hope that everyone has had time to review those minutes, and we'll entertain a motion to approve the minutes.
So moved.
Is there a second?
A second.
Great. Is there any comments on the minutes? I don't know if we take comment after the move and second. Now I can't remember.
We can.
Okay. Seeing no comments, I'll call for the vote. Staff, please call the roll.
Don Smythe.
Approved.
Grace Hum.
Approve.
Susan Bakshian.
Approve.
Nidia Duenas.
Approved.
Devin Kenyon.
Approved.
The motion passes.
Great, thank you. We're going to move now down to our staff reports. I believe the virtual oath card we're going to hold for 12 more minutes until they join us at quarter till. So can we move forward to the report for the February bar exam?
I'm ready to report. Good morning, everyone. The February 2022 California bar exam, as you probably recall, was administered on February 22nd and 23rd with a small number of accommodated applicants testing over extended days. This was our first return to an in-person exam administration in 2 years. I want to publicly thank all the applicants for their patience and attentiveness regarding the proof of entry requirements for the exam. The attention the applicants paid to the communications we sent out about vaccinations, COVID testing, masking, etc., really helped with a smooth check-in process at all the exam sites. And I want to thank you and the law schools for helping to amplify those messages. We were sending weekly emails, and if you helped to amplify what we were trying to highlight about those proof of entry requirements, I really appreciate it. I also want to thank the Office of Admissions staff. They really geared up for a very special in-person exam with all those extra moving parts. And then we had a lot of state bar staff outside of the Office of Admissions volunteer to help at the bar exam site, so it was a real team effort. For the exam itself, we had 3,450 applicants that attended, 12 partials, and 408 no-shows. Any questions about the February exam? Okay, on to the July 2022 bar exam.
It looks like Dawn has a question.
Oh, really? I'm so sorry, Dawn. Ask away, you're on mute, or else I'll read your lips.
Sorry. I was slow to raise my hand and I forgot to unmute. I did want to ask if the number of no-shows was unusually high on the February bar. It was not.
It was not. No, actually, I think compared to other exam administrators, it might have been a percentage-wise a little lower. It was not. Yeah. Now on to the July 2022 bar exam. Last week we posted FAQs. I'm not sure, since we're not at the stage yet where I'm sending out those weekly emails, you may not have refreshed the bar exam pages to know that. So I want you to know We posted new FAQs related to the July exam. Please take a look. Remind applicants to read through the FAQs. Let me know if you have any questions about what is posted. Until April 29th, applicants can apply for the upcoming bar exam with a $50 late fee. On April 30th, that goes up to a $250 late fee. So that might be a helpful reminder as well. As of today, this morning, we have 6,003 submitted applications for the July exam. If you have not noticed that we updated the test center page, we did add Anaheim Convention Center to the Southern California testing locations earlier this month. The results for the February bar exam will be released after 6 p.m. on Friday, May 6th. And that will also be the time when the July bar exam application will open for immediate repeaters. Any questions about July?
One of the questions I have really sort of is a connection between February and July, which was, I heard from multiple bar takers at multiple different sites that the instructions, the giving of instructions felt a little rusty. And I thought that that was probably just because staff had not done it in a while. Has that sort of been revisited with the people who are sort of managing the proctoring to make sure things are going to be a little bit tighter in July?
Absolutely. Thank you for mentioning that. Yes, rusty with that in-person exam administration. And then over the past 2 years, the proctor pool shifted a lot. So some of the, maybe some of the old hands that used to come and were coming to exams have, for whatever reason, they were not able to come to the February administration. So we had to sort of shift some staffing of who was doing the instructions and announcements. And yes, that is absolutely top of mind for July to make sure that we have the right people reading the instructions and announcements for our in-person administration.
Great. And similarly, and I realize like news is changing very fast, but sort of, is there an expectation that rules related to masking and vaccination are going to change for July, or you all don't have crystal balls yet to know what's going to happen in a few months?
That's probably more like it. So what I've put in the FAQs is everything is subject to change. And as you know, right now, based on all the city, county, state guidelines, federal guidelines, the masking requirements, you know, we've put it in the FAQs that applicants are free to wear masks, of course, but they are not required. But yeah, it's all subject to change. So we'll see how things evolve over the next couple of months. But as of right now, that's how we have it in the FAQs.
Good. And then the last question is also COVID related, because that's all we want to talk about, is sort of since sort of the masking has changed, I suspect there will be more requests for people who have sort of feel like they have specific COVID related accommodations needs. And so how will the bar be handling those for people who identify as immunocompromised or something like that, something that is different than a traditional accommodation?
They would apply through the testing accommodations process. And I have that as a question on the FAQ as well. So they would apply similarly to anyone who wants an accommodation.
Great. Thanks, Audrey.
No worries.
Any other questions related to July? Great. Thank you. Natalie, I see.
Susan has a question.
Oh, I'm sorry. Oh, yes, go ahead.
Sorry, like Dawn, I was slow getting my hand up.
Okay.
I just wanted to confirm, do we anticipate that there will be any differences in locations? Because I know that that was an issue a little bit with February, that the larger locations had different masking and vaccination rules. I mean, I realize right now we expect them to be open, but should things change, I would think that what would change was that the larger facilities might have different rules than the smaller ones. Are we anticipating a similar kind of situation as for February?
Again, if there's, it's subject to change. So if there is something about the size of any of our centers that requires, by state or county guidelines to change our masking or vaccination rules, then that would be subject to change and we would follow those guidelines.
Effectively, though, it sounds like it could be different based on sort of where the test center is at.
It could be, and honestly, we had the same requirements for all the test centers, even the smaller ones, but we could have had, because the large gathering sizes were different, we could have had different guidelines, but we had the same stringent guidelines for all of our test centers in February.
Great, thank you. Grace Hum has a question.
Can you tell us a little bit about ExamSoft and how that's moving along, right? I understand, right, in the prior virtual administrations, right, the AI proctoring, right, was a whole thing. It's not anymore because we have live proctoring, but just talk a little bit about how ExamSoft is working for applicants.
So how it works in person, sorry, there's one. So the ExamSoft, the main software is Exemplify, and that's how you, when you take the exam on a laptop, and you do have the option to always take the exam as a handwriter, but when you take it on a laptop, you get the questions in person in a booklet, and then you type your answers into Exemplify, which is basically just this answer window for all the written portions of the exam. You do have one required mock exam, so people who are brand new to ExamSoft Exemplify know kind of the features and how they can, use that answer window and submit their answers. They also get the exam files ahead of time, but there's no questions in them. They are just those windows so they can open them on site. And then they upload everything, and that goes into our backend to send out to our graders. It's a much simpler process than what was layered on for the remote exams, because that had what was called Exam ID and Exam Monitor, which was the checking your baseline photo for your ID and then being monitored and recorded by the AI that was then reviewed by real live proctors and then state bar staff. So the way it works for the in-person exam administration, you download the software, make sure you don't have any old versions from your law school, you do the required mock exams, you get the exam files, and then on site it's pretty easy to type in your answers and then they upload.
Great, that's helpful. And just one other question. Were there any technical glitches in some larger wholesale fashion, or complaints or concerns about the software?
No, and what happens on site different to what you can do remotely. There were no issues with the software, but if an individual has a problem, like if somehow they brush their laptop off the table and it crashes to the ground, in an in-person exam, they can get a handwriting booklet and switch to handwrite the rest of the question answer. So it's differently administered. If something happened like that in my home and I broke my laptop, then that would be, they wouldn't be able to continue, but we can switch to handwriting packets in person.
Great, thank you.
Great. Does anybody else have any questions for Audrey about July, February, or
anything at all? Yeah.
Okay, seeing none, we'll move forward. Natalie, I don't know where we're at in terms of the folks for the virtual oath cards. Are they ready?
We have them here, and they are so ready that they are ready to start 2 minutes early. So I will promote them to panelists so that they can join the presentation. We are very pleased to have with us from our IT department, both Rick Rankin and Patrick Can, who are working on our e-oath card process, which was rolled out successfully last year. And they're going to talk to you about some additional enhancements that are in the works and also get some feedback for you, from you. And they should be coming online now. So Rick and Patrick, do we have you as panelists?
I'm here.
Thanks, Patrick. And I see.
Hello,
Rick
everyone.
today. Welcome. So we'll turn it over to you and also Audrey.
Fantastic. Audrey, do you want to say anything up front?
Oh, well, Rick and Patrick work in our IT department here. They have obviously been instrumental in what we went to. We pivoted pretty quickly to this DocuSign virtual oath card last year. So they're going to kind of give some overview and some what to expect, and then answer questions.
Awesome. And I'm going to take the lead here. Patrick, chime in as we go, as we discussed. But good morning, everyone. Thank you so much for including us in your meeting today. So as mentioned, I'm the IT director for the State Bar. I've been in this role for a little over a year now. And one of the things that we're really focused on is a broad digital transformation that includes simple things like e-signature, as we're doing with the oath cards, electronic faxing. We're trying to get rid of that kind of equipment. But we're also focusing on a lot of interesting ideas around automation, process automation, self-service for attorneys, licensees, agency administrators, and also new channels of communication. So we're really thinking holistically about a digital transformation at the bar. And one great example is, the ability to launch the electronic oath card that we did last November. On balance, I'd say it was a success. We've delivered over 5,000 oath cards. Maybe for some information, about half of them were processed via a notary, another half were processed via an official. And that in itself is an interesting twist to how we use DocuSign, just because we have to give the new licensee the option to select the path they want to take. But we had a really great results. We had attorneys complete their oath card within hours of receiving the link. So something that would have previously taken weeks to get through the process and get in the mail and get to us actually was done within hours. And we had people, set up as attorneys very, very quickly. So, days, not weeks or months, which I think was a really great outcome for our attorneys. As we approach the next exam and the publication of results and releasing another series of these oath cards, we really wanted to take a step back and look at how the first launch went, what we can learn, what we can change. DocuSign is an amazing tool. It's constantly evolving. There are new features that are added. So we've been taking a few minutes in partnership with our admissions team and also the attorney regulations team to think about what we can do to make it go smoother, go better. And we've also engaged DocuSign, and they brought a couple engineers to the table with us to look at what we're doing and critique it and apply best practices. They have a very large public sector use of DocuSign. So all of that led us to identify a handful of changes that I want to walk you through. Before I do that, let me just pause. Any questions on the first kind of setup here that I laid out?
It doesn't appear there are any questions. Why don't you go ahead?
Awesome. Okay, so here are a couple ideas that we're percolating and looking at implementing. I can't commit that we're going to do all of these, but we're certainly taking a hard look at them. My thought here is let's lay these out for you all, and then we'd love to get your thoughts, reactions, and other ideas. Right? You all are closer to the action than we are, so by all means, this is not meant to be a complete list yet, and we want your feedback. But one idea is that DocuSign now has the option to allow the recipient of the envelope to specify the next step in the process. And that's different from the way it's set up today, where it's not quite as clear as it is with this new feature of DocuSign. So the new attorney will get their oath card, they'll complete the registration section, and then they can decide at that moment, are we going to go the notary path or are we going to go the official path? We're going to give them some radio buttons, if you know those little buttons you click on the form. And when they choose a path, it'll also pop up some additional instructions. So we're going to keep reinforcing, okay, based on the path you've chosen, here's what you do next to try to minimize errors that we're seeing. So that we think that is going to tamp down a big portion of the errors there. We're also going to add some instructions as the first thing that the licensee will see when they open the oath card. So right now the instructions are contained in a separate series of documents and FAQs, which is great, but we're also going to include some instructions at the very top of the oath card, potentially even asking them to initial that they've read the instructions, because we did have a number of people that just flat out didn't read the instructions out of the gate. So that's one. We're going to pre-fill some more data from the admissions system onto the oath card to minimize the amount of typing and also to make sure we get the information that they give us. And we're going to be clear on the instructions. If the information that's been pre-filled is incorrect, just erase it and type again, type in the correct information, right? Just correct it for us. And then we're also looking at a kind of interesting idea around self-service in the event that one of our new licensees makes a mistake, wants to start over. We believe there's an option where they can get a new oath card delivered to them via email that they can start over with. Currently, they have to email the state bar and request that. It sometimes can be a delay in them getting a new oath card sent to them. And we're also looking at identifying some best practices for some of the more tricky situations. One that I think you all might encounter is, when you do a group ceremony, and we're putting together some ideas around that. One idea actually came from several members of this group, where you set up a generic email address that attorneys can send their oath card to. And then after the ceremony, you can go through those DocuSign envelopes and sign them all at that moment. So I think one of the email addresses got about 74 oath cards delivered to it, and one had something like 25 or 30. So that was an interesting, I think, learning that we want to share with other institutions as something they might consider if they're doing group ceremonies. And then, so those are the things we're considering so far. I'd love to get your reaction and also any ideas you have.
I'll jump in and say, I definitely would love to sort of see more thought put into sort of the process for when law schools or whomever are doing large swearing-in events. Like even the idea of them coming to us by email is not super practical because we are not actually the people who sort of sign the card. It's the judges, and no judge we know who's ever participated wanted to deal with them electronically. And so what we did in December, I lost all track of time. Essentially, all of our people who are being sworn in, they brought paper ones, and the judge sat there and signed them all, which, the judge had forgotten that's what he had done in the past. So he grumbled about it until I reminded him that that's how things worked long ago and far away. But it made me worry about essentially you all having then to deal with, I don't remember how many 100 PDFs that we then sort of emailed to you. And maybe that is just the best way to handle it. But, if there is some more thought that can go into those large scale events, which, it sounds like more people are doing it by themselves with a notary, which I think is actually awesome and probably sort of easier for the person being sworn in to deal with things administratively, but doesn't change for the like hundreds of students who come through mostly law school swearing in ceremonies.
Right. Yeah, it's a great point. We did notice a fairly large number of officials, mainly judges, who were willing to use DocuSign, which was a nice surprise because we had sort of assumed going in that those were all going to wind up being on paper because, we sort of had the folklore of judges just don't want to deal with DocuSign. We did see a fair number use the official DocuSign form, which then brings it all back to us electronically and saves us a lot of work. So, to the extent we can start to educate judges and find ways, perhaps they could delegate the signing of these to their assistant or to someone so they don't physically have to sit there and click the sign button in DocuSign. There may be some ways to make it so that judges are more comfortable with the electronic signing. And that's something we're working on.
Yeah, I love hearing that some judges did it because I actually think they like to be on trend. And so it's helpful to know that some people made it work. Okay. Susan Bakshin has a question.
I just wanted to echo Devin's comment. I agree that ceremonies could use some smoothing out, especially at schools our size, when we're dealing with lots of folks. And July will be a lot more than we were facing in December. And so I do think what judges are willing to do and have to sign becomes even more important when we're talking about hundreds of signatures at the same time. The only other thing I would add to the ceremony idea is I think we might actually see a return to people coming to the ceremony. Now that these are not going to be virtual, some of these ceremonies will return to live, and these may now become events that are in person again. So I think some of those uptake in notary numbers might have been COVID related, though I suppose that remains one of the things that remains to be seen. Perhaps it won't, but something to consider.
Yeah, it's a really great point about COVID and in person. I think we need to be prepared for that. So thank you for reminding us. One thing we also were considering was, when you all set up your swearing in ceremony, if you could say to the new attorney, if you're going to be joining us, please be sure to email your DocuSign to this address in advance, right? So you could collect them all up in advance. Because my sort of hypothesis here is once a judge figures out that it's like 3 clicks for them to sign versus a piece of paper that they have to physically have a pen on, some of them are going to be happier to do it that way than actually having to sign 100 pieces of paper. Maybe I'm wrong, but one idea would be to preempt that by having the students send their DocuSign to a destination that you define in advance. So,
And it would not cause a DocuSign problem for us then to sort of forward those on bulk to the judge to do the clicking?
Not at all.
Good, that's a good idea. Amy has her hand raised.
Yes, thank you. I was going to note that same thing that Rick has highlighted, that you could do this in advance because the card has also been modified to allow for 3 dates. The date that the applicant signs I guess the virtual oath card, as well as the date that the swearing in officer signs. And then there's actually a date that's collected of when the actual ceremony happens. So that would facilitate the ability to sign this in advance. And I also want to comment on something that Susan brought up that's relevant about this. So, you know, our progress in providing electronic oath packets and also in allowing for virtual swearing in ceremony, they've improved the facilitation of the swearing in ceremonies for law schools and for applicants around the globe. I mean, one thing, this is one of the benefits of COVID is that we've been able to accommodate this and get people the packet in hand and the ability to swear in more easily. And so I just want to let everybody know that we're no longer going to be administering admission ceremonies as admission sponsored, because you know, even before COVID, the number of attendees participating in our ceremonies was on the decline, and our digital transformation, you know, has also reduced you know, the amount of requests for this. So I just, you know, many law schools are reinstating this as reinstating these ceremonies as noted here. So I wanted to, we're going to put it on our website, but I wanted to alert the schools as soon as possible that we will not be moving forward with admission ceremonies.
Great. Thank you. Don Smythe.
Yes, I would also want to encourage the judges to adapt modern technologies. So many of us have become at least moderately proficient with Zoom and other technologies we didn't use prior to the pandemic. I'm completely confident that the judiciary can cope with the DocuSign. And I really like the idea of expediting the swearing in process. I think this would help. I also hope you are able to work out a quick fix for cases in which an applicant, a candidate makes an error in going through the process. Some sort of automatic email would be, I think, a great way of fixing things. And the sooner people get sworn in, the better.
Susan, hand is up.
Sally, just one quick thought. I love all these ideas and changes, and I too hope that the judges will do it in the easiest way for the state bar to process everything. But one thing that would really help us help the judges would be if we had one consistent set of instructions. So if the state bar created a document that said, judges at ceremonies, do this, and please don't do this. That would be super helpful, because I know when my staff come to me, they ask me to craft it, and I'm like, I'm not really sure what best practices would be. And I think you guys know what we do right and wrong, and that would be super helpful. And I think if we were all doing the same thing, it would also be helpful for probably the occasional judge who does more than one of these. If we were all doing the same thing. And the same thing along the lines of, you talked about that initial branch of seeing the instructions for either oath or for notary or official ceremony or notary, or however the students were choosing. I think the earlier in the process a student can identify, I'm going to a ceremony at my school, the faster we get them out of trouble, because they don't know what to choose. And if there's an easy early branch to click on and say, I'm going to a ceremony at my school, I think we save a lot of do-overs and a lot of errors.
That's another series of great points. And my hope would be the instructions say to the person taking the oath, you know, don't start completing the oath card until you know the path you're going to take. You know, are you going to go to a signing ceremony or not? And figure that out up front. Once you know, then go ahead and start down the process. because it's hard to reverse back out again. So we do have DocuSign engineers working on a self-serve option that I mentioned. It's a little tricky because we do have some control information that we need to see on those oath cards. So we're working through all the details of that. I think we'll be successful.
The other question that bubbled to my mind, which I love the idea of people being able to fix mistakes. I'm wondering if people who are being admitted may then also think that that's an opportunity to do name changes. So if that is, that's wonderful. But if that is not the goal, I would make sure it's very explicit. Like, this is not the time to change your name. This is the time to fix a typo. And here is the different process for handling name changes.
Yeah, there is a checkbox on the oath card, and Audrey and team keep me honest here, but I believe there's a pretty clear checkbox if you're going to change your name, and there's a separate document that has to be submitted.
Yes. And that's been incorporated in the instructions, how to do the name change as part of this oath, processing your oath packet virtually.
Right. And that is, Devin, that is one of the tricky parts about this self-serve to correct errors is when we send out the oath card, it's pre-filled and they can't change the names, but it's possible. We're trying to work out a way so in the self-serve option, that same thing happens so that they don't make any mistakes in their name.
And I wholeheartedly endorse making them somehow read the instructions first, like initials or whatever. As a faculty member, if I could come up with a way to do that on my exams, it would make my life a lot better. So, are there any other questions related to this? Natalie, go ahead.
I just have a couple of questions while we're all together. Will all of the schools that are online now be returning to an in-person ceremony this spring? Do we know for sure? Is there anyone who's not sure?
I'm not 100% sure, but I can't imagine we won't be live, but like everybody else, subject to change.
It's helpful for us to know. And then also one of our schools that's using the email is Hastings, Grace's school. I'm not sure if Grace is involved in that specific process, but I'll point out to Rick that the council is available for questions, for feedback as you're putting together your processes and having these conversations with DocuSign. And I would say that the members have been very involved, very specific, very helpful in their comments. And I believe they would be on this topic as well.
That's great. Thank you.
I'm not involved, but I can ask my person who is involved in that process to provide that information if that would be helpful.
It would be terrifically helpful, especially for Hastings, because you have a large class that you're doing this with. And so you'll have a lot of instances to talk about how things are going and the feedback students might have.
Happy to report back then.
Thank you.
Great. Is there anything else on this agenda item? Okay, seeing none, we'll thank Rick and his team for their work and look forward to the continuing evolution of this process, hopefully in an easy way for everybody.
Okay, thank you all.
Thank you.
Thank you.
Great. Is the next thing the blue ribbon update? Am I remembering this right? Did I get out of order? Yes. So can we get an update on the commission, please?
Yes, so we'll turn that over to commission members, Susan Bakshian, as well as commission staff, Audrey Ching and Amy Nunez.
Want me to start, Audrey, or do you want to start?
Well, just thank you for doing the report today, and I might jump in with some questions after you go. But thank you very much for serving on the commission and for doing the report.
Thank you. The commission is a large one, so it's of course a process. There are lots of folks and all stakeholders are represented, including everything from psychometricians to law school folks and lots of different expertise. And so we still have an end sort of goalpost as end of the year for a report, keeping in mind that we are not making changes to the bar exam. We are making recommendations to the California Supreme Court. So we anticipate that report going to the Supreme Court at the end of the year. However, we have made a bunch of preliminary recommendations already, and I'll share with you at least a big picture overview. And if you are interested in the details, these are public meetings, they are recorded, and the full meetings are available online. So if you're interested in seeing the presentations we've seen about different kind of non-exam alternatives, different kinds of things that bar exams can look like. All of that material is archived on the State Bar website and available. And I would encourage any of you who are interested in a deep dive. There's terrific and interesting presentations there. That said, I'll just give you the 2-minute summary. We recently voted to proceed on 2 paths. So the commission has voted to proceed on a preliminary path to investigate both a non-exam alternative and an exam alternative. On the exam alternative side first, the commission is pursuing at this time a California exam, not the UBE. And in terms of the California exam, we made some recent decisions to recommend to the court that there be less subject matters tested, that there be a change in the subject matters tested consistent with the CAPA report, that we also have less focus on memorization and more focus on testing problem-solving skills, where students are given materials and asked to create a realistic first-year task. So that is basically where the exam process is. We have made those preliminary recommendations, and that is in process in terms of considering what that exam alternative might be developed to look like. On the non-exam pathway side of things, we have made a decision to pursue a non-exam pathway. We have made at least some preliminary decisions to pursue it for California law schools. Now, it does not mean just us. That's not just ABA folks. That's California law schools. So those that are approved by the California State Bar as well. So we're looking at all California law schools being part of this. We are looking at it having substantive and experiential components. One thing I think is important to emphasize, one detail that is important, is that the experiential is broadly defined. This is not defined as a live client clinic only. It is defined as lots of things like practica, externships, all the things we do at our schools. So a broad and inclusive definition of experiential learning, some substantive requirements. The idea being that the non-exam path would have a curriculum to follow in law school. It is not a diploma privilege. And what some remaining questions that remain open are whether or not this exam path would have a supervised practice component after graduation or not, whether it would have any kind of exam components or not, and whether or not it would have some kind of a capstone requirement or not. So a lot remains to be determined, and those are the issues that are facing the commission at this time, is how we will develop this non-exam path. There's a little bit of a balance to be found here. The Supreme Court has asked for recommendations. So they have not asked us, what would you do? And they have not asked us to craft it, but they've asked us to make recommendations. But obviously, the more specific those are, the more realistic and helpful it is to the Supreme Court. So we are trying to find that right place where we give the Supreme Court enough information about what a non-exam path would look like, and enough information about what a new California exam would look like. I'm sure most of you already know the UBE will look radically different in the next few years as the next gen exam starts. So we have not elected to pursue the UBE or next gen, but instead to pursue a California exam. You might be very interested in listening to the last meeting where we discussed the CAPA recommendations, and we discussed the change in subject matters and at least a preliminary recommendation to reduce the subject matters to the MBE subjects, the 7 MBE subjects, and an addition of what is broadly called administrative law, which is workers' compensation, Social Security, all kinds of regulatory fields. And a reduction of business associations, trusts and wills, remedies, and community property would be eliminated. So some big changes, but perhaps the biggest one is that we are going to pursue the 2 paths, and that is where the commission is currently working toward making a recommendation that includes both. So I am not sure if I have left out anything critical, but I've tried to be short yet complete. But again, I would encourage you to watch the recordings if you're interested in seeing the presentations on experiential learning, if you are interested in seeing the presentations on the exam alternatives, or the last meeting where we discussed these preliminary recommendations. And Audrey and I can take questions if people would like to ask anything about the commission's work.
Great, thank you. Grace, go ahead.
Just a quick question about your timeline or general timeline of making recommendations to the Supreme Court.
The general timeline is for a report to the Supreme Court by the end of this year. The only reasons I'm a little bit hesitant here are twofold. One is that our chair was Justice Guerrero, who, as you know, was recently elevated to the California Supreme Court. And so we've recently had the assistant chair be promoted to chair. So I don't want to speak out of turn, and that's a large transition. So I would say we are hopeful for the end of the year, but of course, it's more important that we do this right than we do it quickly.
And sorry, when you say the end of the year, you mean the calendar year?
Yes. Well, I should say that's what I understood the announcement to be. Audrey can correct me if that wasn't right.
No, you're good.
Don Smythe.
It's very interesting to contemplate having two alternative paths to a law license. How easy would it be for law students to switch between paths? Would it be something that could be done relatively easily, or do law students under this plan have to make a very early decision, a very early commitment?
I think the short answer is that this will depend highly on what the details of the non-exam path end up looking like, right? So until we see what it looks like, it will be difficult to determine exactly at what time a student would need to make this election, or whether it would be an election at all. And it could be made at any time or a later time. The reality is that some law schools may elect not to do it. They may elect to say, you know what, let's take the exam path. We're not interested in providing that curriculum. Smaller schools might not be able to, right, or interested. Other schools may be, we can easily do both. I envision a path for larger schools that this is not something that would be difficult to offer both paths to your students relatively easily. I can see a little more challenge for smaller schools. And I should add in that comment, that is me personally speaking, not as an official member of the commission. That is my opinion as a law professor at Loyola Law School. So I think some of it is that. I think the other thing we would need to look at in terms of if there is both a substantive component and an experiential component, most of us don't have our students doing experiential work in the first year. There's a first year required curriculum at law schools, and I imagine most of that would stay much the same. So if that stays the same, this would not be something a student needed to decide until well into the second year, potentially even into the third, depending on how your school does your experiential learnings and offerings. They are very popular at my school. In my school, I have many students exceeding the ABA required units in experiential learning. And I expect that is true for most of you as well. So that would make a non-exam pathway less of an alteration to what you're doing than it might initially sound like. And of course, highly dependent on what do we decide it encompasses.
Just a follow up, if I may, I do wonder if the two alternative pathways could lead to some segmentation in the job market, especially the entry level job market. And I wonder whether the students who choose an experiential path, something perhaps a little different, might get locked out of some job opportunities. And I wonder if the potential impact on the market, the job market, has been contemplated by the group.
Commission is focusing primarily on minimum competency, right? That the licensing exam is designed to ensure that students are that the public is protected and that students demonstrate the minimum competency required to have a license for the practice of law. And what we do know, and what we've seen a lot of information on, is that it is wholly possible to do this in a non-exam alternative way and in an exam alternative way. And in fact, what we've learned is that the exam does not do some of the things it should do to be a minimum competency exam. So one of the things that we're focused on is that. Now, a smaller portion of that is, of course, a job focus. And one of the things the commission will look at in detail is the timing of the two requirements, because obviously we cannot create one that can be finished sooner than the other or that one takes years longer than another, because then I think you do create job market disparities. I would not anticipate job market disparities if there is relatively similar timing, or if there is some sort of parallel paths, right, that students can choose both and don't need to. Now, if an employer wanted to say you have to take the exam, they would be free to do that. They're free today to require you to be licensed in New York and California if they like. So the market will do what the market will do. But I think for a great many graduates, employers would love the idea of being able to have them sooner, and without the economic burdens and disparities of 2 months of exam study and then waiting for results.
I have a question about content, because the day after you all sort of approved that part of the recommendation for the exam alternative, I got like 7 emails from faculty saying, oh, does this mean I have to quit teaching remedies now or whatever? And I said, well, you know, your way, don't let the horses run away from you. I think it was especially because the NCBE had put out sort of the test outlines a couple weeks prior, and so everyone sort of got them conflated. When you all sort of put forward a recommendation around the exam alternative, like what level of specificity do you anticipate sort of will be included in that? And if it is a California focused exam, does that mean we anticipate more California law, or are we looking at sort of more of the UBE sort of world of law, whatever that is?
We're not looking at the UBE world of law because we, for example, are going to test civil procedure and evidence, which are UBE topics, but they will include California as they do now. So California topics will remain part of the exam, but also I would anticipate that basic common law doctrines will as well. We are not going to be drafting subject matter outlines. That's beyond the commission's scope. That would be what the exam drafters will do once we make a recommendation. We're making bigger picture recommendations for things like less memorization, less subject matters. But we are not saying within the subject matter, you should cover these things. Though we have heard some expertise and heard some folks speak about the importance of transparency to exam takers of you need to have memorized and understand these concepts, and you need only be familiar with these concepts, and a clearer definition of what must be memorized, and that be a lesser amount of material. As for law schools deciding what to teach, I can't imagine in a million years remedies gets eliminated from the law school curriculum, or community property for that matter, or business associations. I anticipate that all of those classes will remain very popular at law school because they are very important to the fundamental practice areas for some graduates. And what we have said is that for minimum competency to get a license, those exam topics don't need to be tested. It does not mean they don't need to be taught in law school. It does not mean that they are no longer important or relevant. They are. That's not the determination. The determination is, are they what we need on a minimum competency exam? And the CAPA report is based on what lawyers said they're actually using and doing.
Yeah. I'm going to excerpt the video of you saying that, start sending it to my colleagues.
You're probably going to have to add the disclaimer, I teach remedies. So a little self-interest there. But you know, I have lots of students in my class every year who are there only for the bar, and they will go away. But I have lots of other students who are in that class because they intend to be a civil litigator in California, and they want to know how to get an injunction.
Good. The other question I have is, and it may be beyond sort of what you can say, the way you talked about the exam alternative suggested a move towards mostly a performance style exam, and not really sort of kind of the essay MBE style that we've had in the past. Can you say if I'm reading that correctly, or, it's too far out to even say what that means.
I would encourage you to listen to what we heard from the experts in our last meeting about the problems with essay exams and how they are inherently subjective and not good testing instruments. Also, a move away from memorization can be accomplished a lot of ways, right? The national conference has already indicated with the next gen exam, the MBE is going away, right? I mean, there's not going to be this traditional 200 question MBE exam. They're moving to something new. So California will have the benefit of looking at the NCBE testing instruments. But again, it's beyond the commission what the exam will look like, but we have recommended less memorization. We have heard critiques of essays. They're more performance style, and other kinds of testing instruments that are of that nature are under consideration. But again, that will be the province of the Supreme Court to accept a recommendation and to implement it in the way they see fit.
Great, thank you. And I have one other question that probably is for Amy and Audrey, which is, we sort of heard what the plan is for the commission to make their report to the court. Can you talk about what you anticipate sort of bar staff and whoever the court tasked was actually creating the new exam, like what things are going to look like beyond that, and sort of what those next steps in the future might look like, if we know anything now?
Sure, I could address that. So once the court receives a recommendation, and then the Board of Trustees will report recommendations to the Supreme Court. It's really contingent, what happens in those recommendations. Should the Supreme Court decide to move on creating the two pathways, if they're recommended, if it's part of the final recommendation of creating a non-exam pathway and exam pathway, then and an alternative exam, one that is not in the current format, that is less cognitively loaded, like we talked about, and that is moving away from the multiple choice and the essay style question, and creating something that's more of the vignettes or performance-based items. Then the idea would be to move into that build. So building what that new bar exam might look like, as well as building out what the non-exam pathway would look like. So, if those are options that are selected by the Supreme Court as our new licensing constructs, then the next period would be building that out and allowing schools time and giving law schools sufficient time to prepare for that transformation. And as Susan suggested, being transparent about what would be on that exam, like, providing content mapping so that applicants would, what, how much, which topics and how much to study for these exams. So we would need to allow enough time. If you look at, for example, the NCBE's next gen exam and its development, it's a 5-year period. And so that's a potential California as well.
Thank you. Dawn, you have a question?
Yeah, I do have a question about quality assurance, especially with a non-exam alternative. There are certainly problems with the bar exam, and it's well to address them. But the non-exam alternative seems to me to possibly raise some quality assurance issues. It seems to me to place some onus on the state bar to ensure that the experiential learning that's done along the non-exam alternative path meets certain standards. How will the state bar ensure quality standards are maintained in a non-exam alternative?
I can start. One of the things the commission has made very clear is we were not prepared to proceed on a non-exam pathway without assurances from all of the psychometricians on the commission that we absolutely can do this with the kind of security that we have about the exam being consistent and it being uniform and it being fair. And the psychometricians have assured us that we also have some folks who sit on the commission from other professional licensing boards. And we've been assured that this is possible, it is done, and it is a way that you can test minimum competency through a non-exam pathway, and that you can ensure the kinds of consistency. Now, one of the things we would be looking forward to would be thoughts from law schools about what that would look like and what would make you confident. I know most of the law schools, the ABA law schools in California, a lot of us use a common training and supervisor agreement for much of our experiential learning. And we would be looking, of course, for the state bar to take an active role, but we would also be looking for the law schools to take a role as well. So this would be a partnership, not a either or. You would obviously need the law schools to comply with the requirements, whatever they might be developed to be. And the state bar would be involved, of course, in creating consistent training and materials and ways to ensure that non-exam pathway meets the psychometric goals of fairness and access and equity. And of course, minimum competency.
I don't know if you mentioned this already, Susan, but the next Blue Ribbon Commission meeting is dedicated to the non-exam pathway. It's May 5th. So I think if you have the time to either attend or watch the recording, that would be, it sounds like that would be of interest, which is good for us to know that that's of interest, obviously, to other law schools and the ones represented on the commission.
I appreciate very much, Dawn, your comments about what employers react to, how students, when the timing will need to be, and the quality assurances that we're going to need, and the supervision assurances that we're going to need, that this becomes a real pathway to licensure, not an end run. And I think that the way we do these things is by really good communication from the law schools. So I know what always happens to me after these meetings is as soon as we're done, I come up with like 5 things I wish that I had said. If any of you would like to email me or Audrey information that you think of as you contemplate a non-exam pathway, we're very interested in making sure that the commission has as much information as possible and addresses as many concerns as within the scope of the commission's work. And passing these ideas on to me either today or via email at any time that they enter your mind would be terrific. They are very helpful, and they are right along the lines of the very things that we have been raising and have been thinking about as we've gotten started on this pathway.
Thank you. And are there any other questions about the Blue Ribbon Commission's work? Grace Hunt, go ahead.
Amy talked about the fact that, once the report goes to the Supreme Court, it will decide, it will make some decisions about what it wants to adopt, and then some build out would occur. Is it likely that when they start building it out, that they would delegate those tasks to folks working at the state bar, or who are the people, right, that would start working on this? Or is it within the Supreme Court sort of structure of creating, say, for example, the new exam, right, what that looks like? What do you anticipate? Who do you anticipate is doing this actual work?
So Grace, we anticipate working with professional exam developers, especially if we're transitioning into these new structures, so that and I turned off my camera, guys, sorry, because I was having internet interference, so this will help with the quality of my communication. But the idea is that we would work with professional exam developers and our psychometricians to ensure that we sustain the same level of reliability and validity in the upcoming exam, but also to make sure that we are adopting state-of-the-art work that's happening in the exam development world, looking at everything, and some of the things that Susan talked about. Within that is also modality. What is the best method for delivering the exam, whether that's remote, working with test centers, or in person? All of those factors we'll be working with professionals on that entire process, from building the exam to the delivery of it.
Thank you.
Mhm.
Are there any other questions on this item? Great. Thank you all for the report, and we look forward to continue to hear about this as it moves forward. Our next agenda item is a report on State Bar Day.
Sure, thanks, thanks, Professor Kenyon. So I just wanted to get on everyone's radar a new component that we've been offering with success at the State Bar, which is the State Bar Day. This is a program that we put together for law students, particularly California law school students at all of the different schools. We've been putting together a program that doesn't provide them with any additional information that we're already communicating to them. The current channels are sufficient, but it's an additional forum for those students to get together and to hear from our Office of Chief Trial Counsel, our Lawyer Assistance Program, the Office of Admissions, and occasionally also our attorney portion who can help with things like the e-oath card. The program is a general program designed for students at any year. We find that in particular, those in their first year or their final year are in particular enjoying the program. And we most recently conducted one on March 22nd, and we've had several hundred attendees each time. The program includes not only a set presentation webinar style like this, but also an opportunity for students to ask general questions, and we reiterate to them the ways that they can ask specific questions. We've received several terrific suggestions from this, and we've also been able to follow up with several students who had questions as well. We sometimes get the question whether administrators can also attend, and this is fine. What I encourage you to do is to register near the end to make sure that there is enough space for enough students to attend. The State Bar makes special arrangements to increase the registration cap for the webinar to provide service to as many students as possible. And that's our primary goal. And then we'll use these other fora in addition. But if you find on the day or the day before the webinar that there is space, please do feel free. And in addition to the State Bar program, I'd like to remind you that both the admissions office as well as the Lawyer Assistance Program can make available remote custom presentations for your school as well, pending availability and giving time to schedule. So I'm not sure if anyone here in the audience of members has had an opportunity for your students to attend, if you've received any feedback about the program.
Susan Bakshin.
Good news. I had lots of students tell me it was super helpful and really liked it.
That's terrific. And as they're giving you this feedback, if they notice certain things in particular, it's helpful to let us know so that we make sure that we continue to amplify those messages.
The only feedback I've ever heard is students having, why do I have to register for this in advance? Like it is, which seems like a deeply low commitment, but still can be a bar. And so I would just urge the bar staff to decide if that is really necessary and figure out a way that just lets anybody log on who wants to. Like I recognize that there may be perceived to be a technical reason for that, but I think it probably is actually a barrier that's not necessary for people.
Okay, thanks for that feedback, Professor Kenyon.
Anybody else have questions or comments about this agenda item? Great, thanks, Natalie. The next agenda item is a report on the provisionally licensed lawyer program. And after however many years, I may actually be able to say that. So.
All right, so I'm going to share my update here. So as many of you are aware, the Supreme Court updated Rule 9.49, which allowed applicants who graduated from December 2019 to December 2020 the ability to work as a provisionally licensed lawyer under the supervision of a California attorney. That law was also later revised to and expanded to allow applicants who had attained a score of 1390 on any bar exam between February 2015 and July 2020, February 2020, the ability to also participate in the program. But those under the program expansion would also be allowed to become licensed if they had achieved 300 hours of provisionally licensed lawyer supervisor, legal work, as well as received a positive determination or positive reference from their supervising attorneys. So these are statistics as of April 13th. We have currently 249 participants that fit under the criteria of having graduated, and they are not eligible, obviously, for licensing. This cohort needs to sit for a bar exam in order to become licensed. And we have also sent that same group an email reminding them about that. So we did it also before the February bar exam, because if they pass the February bar exam, it would ensure continuity in terms of their jobs or whatever they are involved in for pay or unpaid positions. Also, currently we have 234 applicants that are active in the program expansion. If they meet all of the licensing requirements and have satisfactorily achieved the 300 hours and a positive reference, they could become licensed. And so to date, of those participating in the program, we have 612 that have been admitted to the bar of the graduate cohorts. And that graduate cohort, that means that 612 sat either for the February bar exam or the previous July exam and have been admitted. And 424 have been admitted via the possibility of meeting the 300 hours and a positive reference from supervisors. We have 12 that have been suspended in the graduation cohort, 8 under the expanded, 42 in the graduation date, 5 under the expanded. And these are our totals. We had about 915 that were in the graduation date cohort and 671 under the program expansion. And the suspensions and terminations happen for a variety of reasons. Sometimes people terminate, from going from for a variety of reasons. It could be for moving to another position, ending their positions altogether, and all that have been admitted to the bar automatically terminate their provisionally licensed positions are automatically terminated once they receive a bar number. So that's what our numbers look like. Sometimes the questions that we get are related to the demographics of those that have been admitted to the bar. So this is of those that have been admitted to the bar. So again, this is looking at only those under the program expansion. So of the 424, this is what the race and ethnicity composition looks like for that group. So as you can see here, the majority of PLLs that have been licensed via the pathway are white, followed by 77 are Hispanic Latino, and 74 Asian. So that is the race and ethnic composition. As for the school types, as you can see here, a majority of the licensed PLLs through the pathway come from California ABA law schools, followed by CBE accredited law schools in California. And the other is a combination of international students. All right. As for gender, there's the majority of those licensed via the pathway are female. Now, I'll stop sharing. The couple of things to keep in mind is that the program sunsets June 1st, 2022. So that is coming up. As I mentioned, we have informed applicants about both the exam and also for those in the exam pathway, in the pathway to licensure, we've also informed them and reminded them about the need to meet all of the licensing requirements. So this includes things like having met the MPRE requirements. They have to have passed the MPRE. There was a confusion initially about the MPRE altogether, because in order to qualify to participate in the program, you did not have to complete your MPRE. You could also satisfy that by taking the 4 hours of professional ethics training that are part of the 10 hours of new attorney training in order to participate as a PLL. But in order to get licensed, you still had to meet the MPRE requirement. So we talked to a few applicants that were confused with that requirement. The other requirements include what they include for everyone else, which are again, having met the MPRE, which means you sat for the exam and achieved a score of 86 or above, as well as having a positive moral character determination, which includes the fingerprinting. We do the child support background check, so you can't have any outstanding child support arrears. And I guess the exam requirement has been satisfied through this pathway. So again, those reminders have gone out to those law school students, and that is our current standing with the PLL. Are there any questions?
Don Smythe.
Yes, I am curious to know whether you've done any analysis on how the performance, professional performance of the provisional licensees has compared with the professional performances of newly licensed attorneys in prior years.
That's been difficult to gauge. I mean, that requires some longevity and some time in order to track. What I can tell you is when we look at the numbers of how long it's taken somebody to become licensed, and what I mean by that is, everybody needs to have met 300 hours, for example, in the pathway. How long it's taken each applicant varies. The majority, some reported having achieved that within 1 to 3 months, but the majority have taken between 4 and 6 months, and some have been working longer than that. Because again, the requirement was that you needed to achieve the 300 hours. There was no time estimate as to how long that would take. And some are doing it, part-time, some are doing it full-time, some are paid positions, some are non-paid positions. So it's hard to gauge that. And again, in order to compare performance for these licensees compared to regular licensees, license in the regular pathway, that would be very difficult to assess. We would need some more time in order to make a proper assessment of that.
Go ahead, Don.
A related question, we've just had a discussion about the bar exam, and there are obvious problems with the bar exam. One obvious problem is that there may be biases in the exam and the outcomes. Do we have any comparisons that would help us assess whether the provisional licensing program has worked to the advantage of some groups relative to the usual licensing process?
No, I provided a breakdown of the racial, ethnic, and gender composition just to give some insight as to who's participated and successfully become licensed in the program. But in terms of the bar exam questions, one of the things that's on the agenda today is the results of a diff analysis. This is differential item functioning about related to the bar exam questions. And so I'll have more information a little bit about the impacts on subsets of testing populations that can address a little bit more of that. But as it corresponds here to the provisionally licensed lawyer program, we haven't really dived into that. It's probably an analysis that we could do at a future time once the program sunsets. And we've allowed some time for, some of the newly licensed attorneys to have work experience.
Are there any other questions for Amy? Okay, thank you for the report. It looks like the next item relates to applications to join the council. Is this you, Natalie? And you are muted if you're speaking.
Yes, that's me. Thank you. So this is really a reminder for those who are watching, but also for members who might have suggestions for new members. It is the time of year in which we encourage law school deans and law school administrators from ABA law schools to consider applying to serve on the council, as all of you are today. And this year we have extended the registration deadline significantly to July 1st, and we did that for a couple of reasons. The first one is all of you are appointed by the chair and the new chair and vice chair of the Committee of Bar Examiners, who take their office later in the summer. Therefore, there is time for you to prepare those applications. But also, moreover, we've heard from some schools that because there are continued changes related to the pandemic and hopefully the emergence from the pandemic, some individuals either were concerned to make a time commitment or felt that if the pandemic were in a better situation, they would want to apply. So we do encourage anyone who is watching that may be qualified and may be interested to serve. The applications are on the committee's Law School Council page. And the application has changed in format slightly differently this year. It is now a fillable format, more in line with the other commissions. We think it is an easier process than ever. So for those who are watching in the audience or those referrals you may have as members, we are taking those applications immediately, but we'll be doing so through July 1st.
Great, and I sort of mentioned this in passing to Natalie. It would be awesome if you all could blast out a message to all of us on the council and I guess all the deans so that we can help spread the word and encourage our colleagues to consider submitting applications as well.
Absolutely. We plan to use the list that Audrey generally uses for the e-blast for the bar exam. So that includes not only the deans and registrars of each law school, but any additional interested administrator. And if you're not on that list today, but you think you'd like to be a part of it, you can email either me, my address is on the agenda, or our law school regulation at calbar.ca.gov box. Just tell us your name, contact information in your school, and we'd be happy to add you to that list. So you'll get that communication. Or if you want to email just to get the link for the application up on our website, you can also contact me at either place.
Great. Thanks, Natalie.
You're welcome.
The next agenda item is recent developments. Are there any recent developments that we need to be apprised of?
Yes, there are two. So a short one is just a reminder that the State Bar is continuing to offer to your summer bar applicants the Bar Strategies and Stories program. This program has been very successful. It is a free program that complements and doesn't replace bar prep. It takes less than 2 hours to complete, and it helps applicants to adopt a productive mindset while they're studying for the bar exam. The program is offered in 2 waves. The reminder for the most recent wave went out yesterday. Your applicants are signing up when they register for the bar exam, or again from one of the custom links in the email reminders that they get. And they're encouraged not only to sign up for the program, but to execute the program as early as they can in their study. We've seen very promising early results from this program. It is not conducted by the State Bar directly. It's created as an academic program by a consortium of professors in a variety of disciplines, and we're looking forward to providing future updates about how that program is proceeding. We encourage your applicants to sign up. We have a second recent development. I'll turn it to Audrey.
Hey, thank you. So hopefully you saw one of those broad distribution list emails this Monday. We are looking for volunteers to help with the content map review and the multiple choice item review for our first year law students exam. In the email, it also said to feel free to pass it on to anyone else who is interested. We are looking to revise the first year law students exam multiple choice questions this year. That application does close on May 2nd, so which is a short time frame. So I just want to remind you, if you have seen something but maybe you didn't circle back to it in your inbox, that is from that law school regulation email address. That is our exam development staff looking for volunteers to help with both the content mapping for that exam and then the actual item review. The details were all in the email, and again, feel free to forward it on. We are fine with getting a broad spectrum of applications for that review.
Thank you.
Thank you.
Our next agenda item is a presentation on the guiding principles in exam development to minimize potential bias in bar exam questions. I'm very literate today, so we'll go back to our staff for that.
All right, well, this is Amy, and we have a PowerPoint we're about to share. So you might be aware that we developed guiding principles under the direction of our Board of Trustees after having completed a differential item functioning assessment. Can we go to the next slide, please? So what is DIF? DIF is not synonymous with bias. It's a statistical procedure used to evaluate performance patterns on specific questions across groups of test takers. And so when we see DIF, when DIF is assessed, it occurs when test takers of approximately comparable knowledge and skills in different groups perform in substantially different ways on test questions. And it helps identify potential issues in a question. So for this analysis, applicants were compared based on their MBE scores in order to ensure that we were comparing the same knowledge and skill set from one group to the next. So as I mentioned, it's not synonymous with bias. It's a method for identifying an item and exploring what can be contributing to that differential. And so part of DIF requires further analysis once these items have been identified. So ultimately, as noted here, it helps ensure that there's fairness in tests. So the next item, please. So we, or next slide, for this project, we employed, oh, hold on one second. So we used a vendor, Scantron was our vendor to help us conduct this analysis. We looked at 20 exams across a 10-year period, so from July 2009 to February 2019. Approximately 116 essays and 36 performance tests were assessed. And it resulted in looking at 72,165 first-time takers. So looking at that analysis. And the variables that were assessed included gender, race, ethnicity, law school type, the subject matter. So these are the subject matters that appear on the exam, as well as looking at whether there was an impact based on July or February administration. I noted earlier that the groups were assessed using MBE performance. That is how we're able to hold constant the test takers' underlying abilities. And so DIF, again, is flagged on the size of the difference, as well as, and it looks for statistical significance within that. Next slide, please. And so these are general findings from the DIF. So female test takers were flagged with DIF on 20% of the questions, in favor of female takers when the MBE's performance is held constant. As for the topic areas that DIF was flagged for, for females, it was in the less frequent subject matters such as trusts, wills, and community property. As for race and ethnicity, here what we see is that the largest number of items that were flagged were in the, and for race, were in the Black and African American category. The diff analysis had 16% flagged, followed by Asian at 10 items, so 7%, non-Caucasian 5%, and Hispanic 5%. So although there were few items that were flagged for race and ethnicity, all the flag items indicated that Caucasians performed better than each of the focal groups, again, after controlling for the overall performance on the MBE. Non-whites also had a moderate disadvantage in these areas, in contracts, evidence, professional responsibility, real property, and torts. Next slide, please. As for the school types, in all the cases, the California ABA law schools were designated as a reference group, and the focal groups were each of the California accredited, California registered, out-of-state attorneys, as well as those from foreign jurisdictions. So 12 items were flagged for diff in favor of the California ABA law schools. Of the ones that were flagged, only 6 favored focal groups after controlling for the MBE and for future differential item functioning. A large proportion of those were flagged in the registered law schools at 64%, as you can see here. Foreign attorneys, foreign JDs, 75%, out-of-state attorneys, 55%, and the rest, as you can see here, out-of-state ABA schools, 30%. And one of the factors that contributed also to the flag in this category was the large sample size difference that contributed to some of the flags as well. So what does this mean? So although there were these flags that happened, although there were these flags, nothing rose to the occasion where we felt like that the outcome could not be addressed by further exploration and using this tool to aid in becoming more sensitive to building a culturally fair exam. And so when we looked at these results, the board directed us to establish a working group that would help develop a set of guiding principles to be used in future exam development. And again, the goal was to reduce potential bias that may lead to diff. So this joint working group included members from the Committee of Bar Examiners and the Council on Access and Fairness. And they were tasked to look at, to dig deeper into the diff findings to determine any patterns or trends that could help develop guiding principles for exam development. And so the group started meeting in December of 2020 to review the flagged items, and they reviewed items that had high and as well as low diff ratings. And they were asked to review these individually and collectively to look at the various forms of bias. So these are the different biases that they looked at. So they looked at gender. Does the exam question contain any language or concept that's suggesting any gender bias? For culture, does the exam question contain any language or concept suggesting any culture bias? And the culture had a broad definition. Did the question contain any language or concept that may be found offensive for any reason? Did the question contain any language or concept that may be perceived as perpetuating certain stereotypes? Did it appear to represent certain groups unfairly? For construct irrelevant knowledge, the issue here was, does the exam question, whether in the language it used or how the issue was presented, appear to require applicants to be knowledgeable in certain areas that are irrelevant for the main issue in the question to be answered with competence? And the last item here is, did the exam question contain any language that may put a certain group at an advantage or disadvantage? So the working group met over a few months to discuss their individual as well as their collective findings related to these ratings. And we met with them to synthesize their findings. What they recommended is they didn't find anything that was racially inappropriate, gender inappropriate, or any overtly biased terminology. Also no overt stereotyping or favoring one race or another. However, through the discussion and through these exercises, they were nonetheless able to develop 14 guiding principles that we plan to share. And the first 10 principles are guidance for the exam development, the question development. We plan to share those with all our developers. So this includes the drafters and pre-testers of our exam, the exam development and grading team, which and the performance test. Again, these teams, the EDGE team, the exam development and grading team, oversee our grading process. And the guidelines refer to the content of the exam questions and what should be done and what should be avoided to minimize potential bias. We're also going to be incorporating them as part of our question selection process with the committee of bar examiners. And the last guidelines, the last four, describe the annual training that exam developers should receive. We're trying to do, we have already implemented implicit bias training as part of that. The goals for the question developer is to revisit our recruiting process. So that recommendation makes a recommendation to the CBE to develop its recruitment process so it's to advance diversity and inclusion in the pool. The goal is to ensure that we have varied perspectives and backgrounds and experiences, all while maintaining the necessary level of exam development, grading, and pre-testing skills and expertise in this process. So we will be disseminating a copy of those 14 guiding principles to the group. But with that, I just wanted to open it up and see if anybody had any questions about the DIP process or the guiding principles themselves.
Does anybody have questions for Amy? Okay, seeing none. Well, thank you for the report, and we look forward to seeing those guiding principles. The last thing, oh, Grace Hunt, I'm sorry.
I'll just say, I don't have any questions, but I really appreciate this report. I appreciate the undertaking of the project to figure out what is happening with the questions and how people might read these questions, your sort of statistical analysis about this. I mean, it really makes me think about what we can be doing at the law school level on these issues too, because you are probably hearing, right? Our students have lots of things going on in their lives, and reading an exam question that is difficult for them to process for one reason or another is yet another thing that can be difficult. So I just appreciate the work that the State Bar is doing on this issue. And despite your analysis that is not finding particular biases, that you're still working towards best practices. And to me, that's inspiring. So thank you.
Thank you.
Well said. Are there any other questions or comments? Great, thank you. The next agenda item is the information on the 2022-2027 State Bar Strategic Plan Initiatives.
Okay, thank you. Thank you, Professor Kenyon. I was not sure if all of the members were aware of the State Bar's strategic plan and how much public access there is to that plan. So I wanted to just give you a very, very high level overview of the plan, let you know where to find it on the website. And in so doing, it'll also refresh individuals about how to access general materials from all of the commissions on the State Bar website, including the Board of Trustees. So I'm going to share my screen and show you a couple of different sites. So I'm sure you've all been before to the State Bar website. And if you type in mission in the search box, you'll be reminded of our mission, what we do and why we do it. And on the bottom of that mission page, you'll see the State Bar's 5-year strategic plan. If we were to look at that right now, you'll see the updated 2017 to 2022 strategic plan that has been guiding the work of the State Bar for the last 5 years. In addition to that, the Board of Trustees has been working on creating the strategic plan for the next 5 years. And just as you find the meeting agenda for today's meeting to come to the Law School Council, the Board of Trustees has its own section set up in the very same way. In this case, I happen to know this was discussed at the March meeting. I could go to the archive to 2022, find that March meeting of the Board of Trustees, and then that would allow me to bring up a full discussion that all of you can see. This is posted for the public. There is an information about the presentation on the adoption of the plan and an actual item that the Board of Trustees considered at that meeting. And if we were to drill into it, you can see there is a memo that describes the process that was used and the consultant that we engaged to assist us in that process. And using the consultant allowed a couple of opportunities. First of all, it allowed for a very broad process, just as we really appreciate the feedback that we can seek from you at the ABA Law Schools. The State Bar actively solicits feedback from a wide range of stakeholders when creating the strategic plan. And this year was the broadest outreach that we've ever had in that process. It's summarized here what was conducted prior to prepare for the annual January strategic retreat, how the planning session informed the final strategic plan that was addressed at the board meeting. If we were to have a bit more time, we could review the entire program, but you can see the 2022 to 2027 goals that were adopted by the Board of Trustees to guide the work in the coming 5 years, some of which you have seen here. In particular, we will be working closely with the Law School Council on issues related to diversity, equity, and inclusion. And as to each goal, you can drill down to each goal, find out what the goal is, the vision related to it, the strategies that will be used, and exactly how it will be implemented. And something that I'd like to emphasize is, we've said this before, but we'll say it again, diversity, equity, and inclusion is something that we find that needs to be built in and not bolted on. You'll hear us say that a lot. It is not a separate thought that is discussed afterward. It's built into all of the work that we do. And when you look into these various goals, you'll see the diversity, equity, and inclusion included every time. So we just wanted to make you aware that that was something that is available. And if you find any particular topics in the program when you look at it on your own that you'd like us to take a deeper dive into in the future, we can bring special guests to the meeting for further discussion. Are there any questions?
Any questions for Natalie about this item? Great, thank you.
You're welcome.
Looking at the agenda, I don't believe we have any other topics. Is that correct?
That's correct. I'll just remind members of the public that we had a full public comment period at the start of the meeting, but if any additional comments were generated, you can provide those comments in writing to the address on the agenda or by sending them to the law school regulation at calbar.ca.gov mailbox, and those comments will be shared with all of the members of the Law School Council.
Great. Thank you, Natalie, and all of the staff who attended today. Thank you, council members. I think we are adjourned.
Thank you.
Thank you.
Good to see you.